morning, Mr. Stain. Can you hear us?
Yes, Your Honor. How are you doing today?
We're doing well. We were just talking about you, and I just signed on to see if you were there. Mr. Rich just said that he had received a message about Mr. Deviney. Was saying that you needed a continuance, but we were unsure.
Well, yeah, my assistant said that we sent the diversion agreement out a few days ago, so it's probably going to need continued.
Oh.
Yeah, no, actually, we got it yesterday, I believe. And yeah, we're going to need a short continuance because I think the initial down payment is somewhere around $2,000 or maybe it's $1,700, something like that. So he's going to have to come up with the funds for the initial payment. But diversion's the route we are going to go.
All right. And so how long do you think you'll need? And we can just set a diversioner up here.
Can we do a 30? I think 30 days would be more than adequate in this case.
All right. That would put us about the 26th of August.
That should be fine. I anticipate it'd be on file by then.
Mr. Richard, do you have any objection?
I don't.
All right, so we'll continue this until August 26th at 9:30 a.m.
Perfect, Your Honor. Thank you very much.
All right, thank you very much. You have a good day.
You too now. Bye.
All right. And that's the only Ms. Stevenson.
Mandy Stevenson Docket.
Oh, good. Well, I'm ready whenever you are. I do have Mr. Willard and Mr. Crable here.
Okay, and we've got
Mr. Crable.
We've got the jail. Yeah. And we've got the jail.
Yes,
too.
in the jail.
So let's go ahead and take care of the people who are here in person first, and then we'll take care of the jail.
I think Mr. Crable will be quicker than Mr. Willard. Do we need to sit down here?
Wouldn't hurt. Let me.
Okay.
Now tell me again, it's Mr. Crable?
Yes, Cody Crable
Okay.
is 21 CR 63.
Okay. Wait for Mr. Rich, but
I suppose we.
I just wanted to make sure I had, because you had said that, and then all of a sudden I'm like, okay, where's Mr. Crable? That's who I am, but I just wanted to make sure. Okay, so this is the 2021 CR 63, State of Kansas versus Cody Crable, who's here in person with his counsel, Mandy Stevenson, and of course, Mr. Rich is here for the state. Ms. Stevenson, where are we with this case?
Judge, we have just secured a plea agreement. It is a felony plea agreement. So at this time, my client would like to waive his right to preliminary hearing, and we ask that we put this on Judge Meisenheimer's docket for August 18th at 1:30.
Okay. Mr. Crable, your counsel has announced that you intend to waive your preliminary hearing. Is that the case?
Yes, sir.
All right, and you understand you do have the right to a preliminary hearing in a felony case, which would be an evidentiary hearing where the state would have to show probable cause that this case even continues. And by waiving that right, you're giving up that right to have that hearing. You understand that?
Yes, sir.
And what I always like to make sure people know is that the right to preliminary hearing is kind of a one-shot deal. And if you waive it now, you can't come back and ask for it later. Do you understand that?
Yes, sir.
All right. And is it in your intention to waive your right to a preliminary hearing?
Yes, sir.
And Mr. Richa, does the state also waive its right to?
It does.
Okay, and so I will find that you have knowingly, voluntarily, and intelligently waived your right to a preliminary hearing, and I will set you for arraignment on August 18th at 1:30 p.m. before Judge Meisenheimer.
Thank you, Judge.
All right, thank you.
you. Thank you,
Mr.
Judge.
Mr. Crable, good luck to you.
Thank you.
And then we have Mr. Willard.
Yes, Judge.
And this is 2021 JV1 State versus Peyton Willard. And this is on for disposition. Mr. Richa?
It is, Your Honor, and there was a YLS assessment report done in record time. I'll have the court know as well, so thank you, Sue, for doing that. So we're just here for recommendations.
All right.
I'll go ahead.
Yes, but you may proceed.
Thank you. I just asked that the court follow the suggestions in the YLS assessment report. It's not a surprise to me that Mr. Willard is placed at low risk. It asks specifically that the court find that the overall case length is 12 months, that the term of probation not exceed 6 months, that he obtain a substance abuse evaluation, follow those recommendations, complete 25 hours of community service work, pay court cost of $56, $60 supervision fee, and attorney's fees as submitted. And then just for the information for her court clerk, I'm going to have to produce this journal entry so she doesn't have to worry about that. But I think those recommendations are appropriate. It allows Mr. Willard to get some information that may be helpful for him in the form of the evaluation, and then be able to move on as an adult now and hopefully be successful.
All right, and Ms. Stevenson.
Judge, I agree with all of those recommendations. Just a little bit of information about Mr. Willard. He is local, has lived here all his life, I believe. He does have a full-time job and then also does side jobs as well. Even though I know he doesn't like to be in this position, he has been a great client. He works very well with me, and he is constantly in contact and inquiring about things. So I think he will do very well on probation from Ms. Hagman. And we'd ask the court adopt the recommendation from the YLS assessment. Thank you.
All right.
And I guess I should clarify, Judge, it does recommend that the supervision be with court services.
Okay. That's a specific finding we have to make in this case.
Well, it's that or community corrections, and I think specifically
Right.
showing with court services would be appropriate.
Okay. And Ms. Hagman, thank you for your prompt attention to this report. We really appreciate it. And I'm going to follow the recommendations of both counsel and the agreed recommendations, and adopt the YLS assessment report recommendations. And Mr. Willard, I'm going to find that the case length limit is 12 months, and the term of the probation will be 6 months to be served with court services, and that you obtain a substance abuse evaluation and follow those recommendations, and complete 25 hours of community service work. And I'm going to assess $56 in court costs, $60 supervision fee, and attorney's fees as submitted. Anything further from either side?
I don't believe so, Judge.
All right. Well, Mr. Willard, thank you very much, and good luck to you. All right, let's move to the people in.
Oh,
Good morning.
Hello.
Thanks for your patience.
Yep.
Ms. Stevenson, do you have a preference of which client you'd like to take up first?
Let's take Mr. Burnett because I need just a few minutes here with Mr. Richard.
Okay, can you get Mr. Burnett?
Okay.
Thank you.
I would just ask that you let me know if there's anything I can do to help. And I think
that would take care of 90+%.
And I think it would be something that has a reintegration plan. That's why.
Ideally, for him,
And he
that's to be even better.
All right, we're here with Mr. Burnett and his 3 cases. Ms. Stevenson.
Thank you, Judge. I have spoken to Mr. Burnett and also to the prosecutor. We need just a little bit more time to work on these. My client's aware of his bond and is aware that he is not able to make the bond. Also, in the things that we're working on, it's going to be best for him to stay where he's at right now. I've talked to him about that. He has agreed to that and has agreed to me not arguing any kind of bond right now while we continue to try to work on his cases. So I'd like to push this out maybe 3 weeks. Give me some additional time to talk to Mr. Richard and see what I can do to help Mr. Burnett. He's in there on 2 PD misdemeanor cases as well as this new case. And I think that about 3 weeks will probably give us plenty of time to work through the PDs, see what our options are, and then make a decision on how to proceed.
All right. Mr. Richard, any objection to continuing this for 3 weeks, which I think would put us on the 12th of August?
No, Judge.
All right, so we will continue these 3 cases until August 12th at 9:30 a.m.
Thank you, Judge.
Thank you.
Thank you. Thank you, Mr. Burnett, and we'll see you in a few weeks. I believe is next. Can you hear us?
Yeah, I got you.
Okay. All right.
So you ready for Mr. Hankins?
Yes, I'm sorry. That's why that's why I thought. Can you hear us? But yes, we're ready for Mr. Hankins. Thank you.
Okay, yeah, they were opening some doors and. So.
Okay. Okay. Mr. Hankins is here in case number 2021 CR 126. He just made his first appearance a couple of days ago where I appointed Ms. Stevenson. So Ms. Stevenson, I'm sure you're brand new
Yes,
on this case.
I am, Judge. I've had a few minutes to speak with Mr. Hankins today. What I'd like to do is ask for bond modifications today, and do that, and then continue the case out a little bit, but I'd like to wait and determine how long I want to continue it based on what really is on the OR or on the bond.
All right, and so we will take up the bond issue.
Thank you, Judge. I believe the current bond is at $25,000 or $26,000 30. My client is a resident of Cunningham who's lived there for over a year. His parents live there. If he was released, he'd be living with them. They've been there for about 3 years. I do have phone numbers not only for him, but also for his mother, and I have the address of where he would be living in Cunningham. He's been unemployed for about the last 6 or 7 months, but is looking forward to gaining employment. At this time, I would like to ask for an OR bond so that he can be released and check into some options as far as drug and alcohol treatment, and also get employed. I believe what I'm seeing on this case would put him in a presumptive probation category. I have to do some double checking on that, but he is a local resident. I'm confident based on our conversation and just the level of intelligence that he had in that conversation with me that he understands that he needs to keep in touch with me. He is also willing to report to court services if the court would require that. He is not very far away from Kingman, and he also has phone availability to be able to call Sue Hagman via phone and report in person if she requires that. At this time, I'd ask for you to grant us an OR bond on this matter and allow the case to be moving forward.
All right, thank you. And Mr. Richard, what's your position?
Well, Your Honor, I'm concerned about an OR bond in this case. We do have multiple items as alleged that are stolen from different people that were found in Mr. Hankins' possession. He does have criminal history that involves theft. We are a little bit unsure on the criminal history. It looks to me like it's pretty close on whether this is a presumptive probation or presumptive imprisonment case, which makes me very nervous, of course, in any felony to have an OR bond. I would suggest that if the court is inclined to do that, that maybe some electronic monitoring or some additional safeguards be put into place to kind of alleviate some of those concerns.
All right, Ms. Stevenson, your response?
Well, Your Honor, my client has been unemployed for the last 6 to 7 months. I think getting electronic monitoring would be very difficult for him. I did not ask him about that option, but if he doesn't have money to bond out, I question whether he had money to pay for the electronic monitoring. I think reporting in court services as she deems appropriate based on his reporting to her would be secure enough to ensure his appearance at court and the safety of the community.
And count 1 is a felony, correct?
Yeah, it's a level 5 drug felony.
Okay. Where I've had problems before on, because I've done OR bonds on felonies before and had then lost track of people, but mostly that my luck with that has been with people who are outside the area. Since he's living in Cunningham and his parents are there and he has a place to stay, Mr. Hankins, I'm going to grant an OR bond. I'm going to set it at $2,500. So if you don't show up for court or don't abide by the conditions of your bond, then you could be on the hook for that $2,500. I also want to put in place, I agree, I don't think Mr. Hankins can afford electronic monitoring, but I do think we can require, I want to require him to report to court services. And just to add a little bit more to that, I'm going to order that Ms. Hagman have A&D authority. That's arrest and detention, Mr. Hankins. And so, I'm also going to order as a condition of bond that you not have any contact with any witnesses in the case, and abide by all conditions set by the court services officer. And so, Mr. Hankins, what that means is that if you don't report to Ms. Hageman with the court services office, she doesn't have to come to me and ask for a warrant. She can just have you arrested and put back in jail.
Yes, sir.
Do you understand that?
Yeah, I do.
Okay. And so we're going to see how this works out. Of course, keep in contact with your attorney, and it will be a lot easier for you to do when you're out of jail. And then I'm going to grant the OR bond in the amount of $2,500 and put you in pretrial under pretrial supervision. So when you get out of jail, be sure and contact our court services office and get signed up with them. Okay.
Okay, and that's here in Kingman.
Yeah, that's just here in the that's here in the courthouse on the 4th floor.
Okay, all right.
And then Ms. Stevenson, I'm sure we'll have more instructions for you.
Okay.
And then what do you want to do about the next court date?
Judge, I would like to go 3 to 4 weeks out. I would like to tell Mr. Hankins, I need you to call me when you get released so I can tell you more information. But I think 3 to 4 weeks would give us enough time to work through the discovery and determine what direction we need to go in.
That would also be the 12th. Mr. Rich, any objection?
Under the circumstances, that seems appropriate.
Okay. Mr. Hankins, I'll set you for your next court appearance on August 12th at 9:30 a.m.
Okay.
And since you'll be out on bond, you'll need to come to the courthouse and appear in person.
Okay.
And also, I want to add, just to make sure everybody's clear, on this bond, I have also ordered that you abide by all conditions set by your court services officer, which also means that she could require drug testing from you. Yeah, I mean, so you understand that. So it's in your best interest not to do any drugs while you're out on bond.
Yes, sir.
Thank you, Judge.
All right.
Thank you,
Thank
Judge.
you. Is there anything further from the defense?
No, Your Honor.
State anything further from Mr. Hankins?
No, sir.
No, Judge.
All right. All right. Thank you, Mr. Hankins, and we'll see you in next month.
All right, thank you, Judge.
Want to go to I think that's all we have in custody until 1:30.
Okay,
Okay, thank you very much.
thank you.
Mr. Boyle?
Bowley.
I'm sorry, Mr. Bowley, on the 2021 TR 401.
Yes. Judge, I'm asking for about a 30-day continuance on this one. We're still waiting on some KBI lab results. I haven't seen them and I don't think Mr. Rich has received them. So need a little bit more time to see if we can get those.
All right.
I was just double checking that to make sure we hadn't received it. It doesn't appear like we have. So
Okay, no objection.
no objection.
So
Thank you.
So we'll continue this until August 26th at 9:30.
Thank you.
And then Ms. Granman Greenwood.
Your Honor, on this one, the last I knew she was in treatment. The treatment facility was not cooperating with me as far as trying to get additional information. But I have not been able to reach this Grandma and Greenwood myself. The information I got about the treatment was from the friend whose phone number she had given me because her phone was not always on. So I'm asking for a continuation.
Okay, and but you do have the name of the supposed treatment facility?
And I've requested that they ask for to sign a release so they can talk to me. I've sent a letter which was returned. So at this point, to be honest, I can't verify that she's even there. I looked into it based on the information I got from her friend. And it made sense to me because she is also on probation out of Sumner County and they were requiring her to go treatment. So it made sense that she would be there, but I've not been able to verify that on my own.
Does she have a probation officer in Sumner County?
Probably has an attorney over there too. I haven't gone that route. I'd be happy to do that if you give me a week to do it.
Okay, Mr. Richa, what's your position on this?
I don't believe Miss Graham and Greenwood has appeared in quite some time. I know Miss Stevenson has been doing her best to follow up, but I think we were basically in the same position the last time. Of course, Miss Stevenson attempted to try to figure out and confirm some things in the meantime. I'm going to ask for a bench warrant for failure to appear. I think that's the appropriate remedy at this point.
Now, just a hypothetical here. So if she is in treatment and I issue a bench warrant, are they going to go grab her out of treatment?
If the treatment facility finds out, they could. Typically, I guess the only experience I have with that is that they won't allow somebody to come in if they have an active bench warrant. But if she's already there, I'm not sure that it would. I mean, they could if I don't.
It really would depend on the treatment facility, I'd imagine. And I don't know if they check that at all. So I couldn't really tell you.
So, I mean, I guess it would be how aggressive they are on the bench warrant.
Which if it's in Sedgwick County, they're usually not crazy aggressive, at least from a law enforcement standpoint, because they have so much to do. But I don't know if the treatment facility themselves check on that type of thing.
The facility judge is in Newton.
What's in Newton? Okay, so Harvey County, but it's similar, probably similar story.
And Judge, just to let you know, if you give me just a 1 week continuance, I would be happy to call Sumner County District Court and find out who the probation officer is and who the attorney of record was on her case and see if I can gather any more information.
Okay. I mean, if somebody's in treatment, I don't want to pull them out. And if they're in treatment and can't, and you know, that's kind of where we want them. So I'm gonna grant the 1 week continuance, but and Mr. Richa, you can remind me that I said this next week. But if we can't verify anything by next week, I am going to issue a bench warrant. And
Thank you, Judge. I will advise Mr. Richard what I find.
okay, and so we'll set this for 9:30 on next Thursday. It's just hard enough for people to get into treatment, much less pull them out, you know.
Right.
So.
I always think about if we're off the record on the case, I think about
Well, we are live on YouTube.
Oh, well, then never mind. I'll tell you.
Okay. 2021 CR 29 on Joshua Hudson.
Judge, I thought I submitted a continuance order.
You may have,
I think I saw it come back, and she's shaking her head, so, or nodding her head, so.
okay,
I think that one's resolved.
okay. And Wilford Westerman.
Yes, Judge. We have an agreement on that case, and my client is supposed to be having somebody bring in the funds that what are needed to resolve the case. What I'd ask for is just a control docket control hearing on the docket next week to check journal entry, because we should have all of that filed today, if not tomorrow.
All right, Mr. Richard, your understanding?
That's correct.
Okay, so we will set a check journal entry for next week at 9:30 a.m.
Thank you, Judge.
And Peyton Price.
I also submitted a journal entry
Okay.
on.
All right, so yeah, that's in my queue. And that should take care of you.
That's it.
All right,
Thank you both, or all three of you.
thank you very much.